The petitioner is not guilty for the offence under section 324, 342, 504, 147 of the IPC, but this court find the petitioner has committed an offence under 323 and 506 of the IPC. So, I have considered in all these things and she has been released on probation. Yeah. For a period of 6 months for furnishing a bond of ₹1,000 with the satisfaction of the London magistrate. The judgment passed by the Leonard Session Judge in criminal appeal number 7 and the magistrate is set aside with regard to the conviction under section 279 and 338 of the IPC, but the petition is convicted under section 3/181 of the Motor Vehicle Act and directed to pay fine of ₹1,000, ID to suffer simple imprisonment for 1 month. Yes. Like, because I have not some of the documents to counter it. So let it be tomorrow. Okay. Item number. Okay. Item number 4. Let it be for. Not today. Item number 4, not today. Okay. Yes. First, may I please? First, the case of the prosecution before the landed below was that. Just I thought of it. Yeah. Already lordship are the regarding merits and the case of the nutshell of the prosecution. Question is, the fact was this accused with connivance of the Pathan, 2%. What they have done, there was some construction work, that digging of pond. Work was executed. Money was given to labor. Some labor from the villagers were engaged. And this person was the custodian of the entire document necessity as master loan, attendance register, other things. When the money was disbursed in different names, they has saying that it was given to 7 to 8 villagers, some amount has been disbursed. There is a document near about 1,61,000 something. But the offense here, Lordship, can you appreciate this part? That person, first point is never worked on the field. First. Second thing, they never received any. That is the main thing. They did not do money.
Who are the persons?
No, that evidence is not in the lower court. So I am admitting that part who has taken the money. That is missing in the evidence that was laid by the prosecution. But here we have to see the case FIR registered against the employees of the agriculture department. During investigation of the registration of the FIR, it was found FIR lost against the employee of the agriculture department. During investigation and after completion of the investigation, charge is filed under that section 468, 471, 409 and 34 IPC against 2%. One was Panchat Susanto and it's a Rama. He was a surveyor at the relevant point. When the charge sheet filed against this 2%. Lordship, I have gone through the entire evidence. It is of course missing from the evidence by the prosecution that who has received. But here kindly appreciate the ingredients 468 and 471 IPC. 471 is the use of force document. Using of force. Here it is proved by the prosecution before the trial court that master load attended, registered, we have exhibited you to this code below. It was only proved that 7 to 8% came and deposed that the signatures appearing in the two documents are not tallied with the signature of this party. But second party is then who was using it and that documents too under whose custody it was lying past. That has to be seen. That was adjudicated by the first appellant. 468 used the first document. But as per my little knowledge, Lordship, not only some manipulation, overwriting, forging, if a person with a custodian of a document, he has used it as a forged document, used it and claiming that entire amount has been disbursed. Of course, 468, 471 applicable. Next question is 409 misappropriation of government money loss by way of cheating 420 years. Dear Lordship,
468, 471, who has forged the document?
Lordship, because it is only proved that it was used by this one with connivance of the Panchayat, that is Susan. Because the Panchayat Pradhan identified the person in the field that yes, they have executed a work. On the basis of that identification, this person released the entire amount. Lordship, suppose, for example, Lordship, I have possessed a document, custodian, it is my custody, in my local. Suppose my birth certificate or death certificate, some other person, my custody. I did not touch the document. I did not forge the document. Nothing I have done. Suppose, Lordship, by using that document, if some benefit undue advantage will come, of course, using of forged documents cover the definition of 471 and 460. That is my responsibility. Regarding 409 misappropriation, it is of course missing in the evidence that who are the beneficiary, whether the money has been put in his pocket. First question. And the money claiming that persons who are not work and who did not receive the money. The question money which used it, that is missing in the evidence. Kindly come to the evidence. Lordship. PW, who is the verifier? What happened on the basis of the funbearer of the Sanjay Mistry Jupiter complaint? When he realized and got information that some amount has been released in the favor of my father of the Sanjay Mistry, immediate rush to the police station because at the relevant point of time, the father of the Jupiter complaint was in bed and he was admitted in the hospital. Thereafter, he was expired. Other villagers also examined, 7 to 8 villagers. They clearly stated the signatures appearing in attended register, master load, we gave a signature that is corroborated by the reversal. That there is no matching of the signature of 7 to 8%. So kindly come to the imposition of PW2.
Part of the appeal.
Part of the.
Yes.
May I read first?
Yes.
I am, the name is Sri Vinod Kumar. I am now posted at Campbell as agriculture officer said. I was posted with the soil conservator at my mother in the year 2007. Which utilized Rajiv Gandhi Rehabilitation Program Fund examination of Image Fund and construction facility. One of the beneficiary of that fund was Jagannath Sikdar. Assistant Director Soil Conservator was his controlling of the utilization of the fund. To facilitate the program, Directorate engaged to enter the implementation of the program. Surveyor Ramara, it is relevant. Surveyor Ramara was given the responsibility to maintain the attendant register master road in respect of this program for 3 panchayat, namely Harinagar, Basantipur and Swadesh. One construction of M1 pond was made in the lead of Jagannath Siddhar, resident of Basantipur Panchayat, and village through this pond. Then M. Ramarao was also assigned to supervise the work and to take measurement and for making payment for the said work of said 3 panchayat. M. Ramarao prepared attendance sheet and
Acquaintance.
role for payment to laborers of the work. About rupees 1,62,060 was spent for fund for construction of M pond at the land of Jagannath Siddhar. I collected the state fund of rupees 1,60,000 from assistant director and handed it over to M. Ramara, who was directed to make payment to consultation with PRA member. That another account to expire.
So this part of the evidence, I collected the fund of 1,62,000 from the director and handed over to Ramara, who was director to make. What is the document that he?
I will come. There is order in. It was executed.
No, this amount, because there is a, Mr. Kabir has shown yesterday. Where is the document to show that 1,60,000 was handed over to Mr. Ramara for disbursement?
I will try it. I will try it. Whether there is a document. I have seen one document also. May I read?
Yes.
Next. Pradhan of Baranpur Panchayat was in Susanto Bichi. Pradhan used to identify the workers who were engaged to do the job before receive payment of their work. Pradhan used to sign in the accountant book. About rupees 3,770 was not paid to one worker, namely Dhire District, the father of defective company. Actually, case initiated from there. Case initiated 3,770 was not paid to one worker, namely Dhiren Mistri at that fund, that is office work as they expired prior to receive the wages. This money was deposited the court account by Chala. It is admitted to London Finance pointed out, they was deposited to the government. Then exhibited documents, I will not read out. Kindly come to the process. Lordship, it is of course the burden of the prosecution to the case of the prosecution beyond all reasonable. But what is the meaning of a cross examination? Suppose I have deposed in chief that this is happened. Suppose that in cross examination nobody has denied it. So court of course come to the conclusion here. It is the good evidence which is stated in chief. Kindly come to the cross examination by Rama. Page number 73.
Yes.
I may be reached not.
Yes.
I was posted at Mayavandar since the year 2004. in R and GRP was launched in the year 2005 and 6. And M. Ramarao was engaged to look after the respective job that is of the program on the strength of office order. His admitted position cannot deny that he was entrusted with that. First, when you see the Ramarao job, I also used to supervise the job. I also used to supervise the job. It is the admitted position that during the work he used to supervise, who was working the field. That is verified. Then,
No,
concern,
I was posted in Mayabandha 2004. So and so, so and so. Ramarao engaged to look after the respective job on the strength of the office order.
it may come, Aisha was given,
Correct.
then it is come out from the mouth of.
I also used to supervise the job. I used to supervise the job.
That's.
Vinod Kumar.
I also used to supervise.
Correct.
It means he is a part of that team. He also used to supervise, including the survey drama. Then, both the concern of Panchayat Pradhan representation, no payment could have been made to the laborers. P. Ramarao, myself, and the civil engineer were on the local public of that area. M. Ramarao was authorized to maintain master road attendance record of the work at the said three panchayat. That made it position, it cannot be denied that Ramarao was using that part. Then process division, then Pradhan and PI furnished the list of work would be engaged to perform the said part. It is admitted position. The panchayat has provided for that reason. Panchayat Pradhan also cited as a accused number in the instant. The job was completed as per the specification. It is admitted to the job was completed, payment was made. Then cost is of the start. Then cost was closed first. There regarding that file, no question have been thrown by the IW Ramarao regarding that part, the statement of the property for engaged maintaining the master loan and the attendance register, no suggestion at all that you are responsible or other things, no question has been cited by that part. Then I am coming to another vital witness, that is expert. I will not read out the one. I will within the record I will submit. The CFSL experts report regarding the signature that 7 to 8 laborers, villagers never work and their signature taken during investigation, which admitted and disputed signature sent to the CFSL, and report has came that no, there is no tally in the signature of other persons. It is only proved by the prosecution that money was disbursed on the basis of the documents. But whether that money, whether it was paid to the concerned anybody, that is not in the evidence either from the side of the prosecution or from the side of the defense. That whether the money was put in their pockets, whether but offense committed regarding the cheating also. It emphasizes this part. Showing some other person who never did the work. First, money was disbursed in the person who never received the money. The question where that is money is lying, whether it was returned to the government or not, that is not within the record. So from the entire evidence, I will not scrutinize the entire thing, Lordship. IWT is BW2 admitted position regarding the ingredients applicability of section 468, 471, 409 being a government servant, 197 sanction was there. Exhibited before this one at trial court, and entire evidence showing that of course there was a some cheating from the side of two accused persons. Therefore, the section 34 common intention was also proved by that, and by that all section charge was framed 471, 468, 409, 409 not against that person.
Why the employment, employee of the agriculture department have been left out? They have also been interested with the crop.
Yeah. What the story of the prosecution I found from the report which was placed before the trial court, that this PW2 part of the execution one. She is beginning, what was given. Who was entrusted, now kindly I will come in that exhibit. Who was entrusted this summer? That is office order is executed number, I will say. Who was entrusted? Being a surveyor, you entrusted by this office order, look after the management.
Look after the management is a different thing, Mr. Kamakar.
Plus, she-
With regard to here is the case, the cause of action of case arose for disbursement of the amount.
plus,
For the disbursement of the amount.
Yes.
What is the allegation? The person who have not executed the work, who has not executed the work,
plus, she-
but the amount was paid in the name of the
In
said
the
person, and one of the person who was bedridden never went to the player, the site.
Yes.
His name was there, and but subsequently it was clear his amount was returned back
Then you get the government.
government. With regard to that, so that portion, it is, though he has admitted, though he maintaining the register, though he maintaining acquaintance route, who has disbursed the amount and how the amount has been misappropriated.
Plus, she- it is in the record that with the help of Pradhan, this drama, on the basis of identification of the person who worked in the field by the Pradhan, then it was disbursed. It was the case up to that part.
Okay.
Up to that part, it is evident.
Okay.
Good evidence is there.
Correct.
On the basis of identification of the Panchayat Pradhan, the amount was disbursed
So if
in
it
different
is,
name.
if it is your case that the amount was disbursed on the identification of the Pradhan, it is your, it is admitted case of the prosecution, he was not of the said village. It is not the case of this Ramarao is not of the said village. He is not acquaintance with any of the person.
Plus,
Correct.
plus,
If the Pradhan, it is your case that we are a member and the Pradhan has given the list
plus,
and prepared the registered, prepared the attendance register and acquaintance roll. So how he can be entangled with regard to misappropriation?
plus, see, since beginning, during execution of work, this person PW2 as well as Ramara was on the field, were on the field. Since beginning, it is not that in one day, one day,
Because the work is completed.
Lossy.
Work is completed, measurement was done, work is completed, payment has been issued. Only with regard to the payment has been given to some other person who has not worked.
Plus,
Where is the identification? This person has worked and this amount was given to that person.
these two persons are the responsible because who was maintaining attendance register, who was maintaining the master rollers, who was the receipt of the voucher that yes, money have been dispersed. These three things, Lordship, these two persons, Panchayat Pradhan and this person are equal responsible for that three documents. Apart from
Okay,
that,
sure.
I am coming. Reports. Yes. 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 Come to the exhibit documents, that is exhibit 17 also.
Exhibit 17.
17 is the office order. Just a responsibility given Ramara survey to assessment director before CO Jilla Police with effect from 1st May 2007.
Correct.
Exhibit 7.
Yes.
Then exhibit 18 is the office order. That is the exhibit 18.
Exhibit 18. Yes, 18.
18. Exhibit
Okay.
18.
Yes.
That is name of the Ramara serial number 9. In continuation of the director office order number 24 May 2003, the service of the following officers are placed on
Jilla Parishad, no problem.
Yes. Then write down. I am sorry.
Now kindly come to the exhibit 19.
90.
Exhibit 19, second page, paragraph 6. Paragraph
Yes.
6,
See.
A.
A.
Yes.
An amount of rupees that is disbursement amount received from SPM Iron by check from the dated and interest on board and annual Kumar. Soil consumer external purpose received also the cash is 5 page number 10. It was
Correct.
taken by below.
Correct. So this is one circumstances, the amount has come to the Vinod Kumar. The evidence made by Mr. Vinod Kumar that this amount is given to Mr. Ramarao for disbursement. Where is that?
That document I am just. So that document never.
So that is one of the circumstances
But
that chain is missing. This 162, 1,62,000 received by Vinod Kumar is admitted, but handed over to Mr. Ramarao is not there.
no document. Okay. Not executed. Just I am coming. Another.
Yes.
In month. Except that part. Just still evidence I am sure. Exhibit 8.
Exhibit 8.
8.
Yes.
This office order number 4. That's now name for the work purpose. He was engaged. That is the office.
Just a minute. Eight.
Exhibit 8. Exhibit 8.
On the top, the red number circle on page 80.
Yes. Yes.
Yeah.
The office order, serial number, name of this accused, Ramaro, Tabiar, what purpose area, Vasantipur, GP, Harinagar, GP, Swadeshnagar transfer.
Correct.
The circumstances, evidence lordship. May I read it on? The under mentioned staff of soil conservation unit and monitor irrigation unit are thereby deployed with immediate effect at the Gram Panchayat mentioned against each for assisting the soil conservation assisted in excavation of the manure irrigation pond and construction of artificial reservoir under the short term action plan of Rajendra with the package for action. Not seen. It is
Not denied. See, it is not the case of the defense.
admitted.
It is not the case of the defense that the Ramarao was not at the place where the work was executed. That is not the case here.
At the time of giving money,
Yes.
it was with evidence, but no documents by the prosecution showing the PW2 was sanctioned actually money. He has given to Ramarao on that event, no evidence, no document.
No document,
No document.
paid the amount to the laborers.
See, that is within the record. With Panchayat, oral evidence is there. Oral evidence is there.
If the amount has not come to Ramarao,
See,
so there is no question that this amount paid by Ramarao to the persons whose name is in acquaintance roll.
coming. That document, but my humble submission is that Lordship, that document is basically not proved by the prosecution before the trial, but it is admitted position and oral evidence. Of course, as some weightage Lordship PW2 was working in that department, he categorically stated.
That's why if the court believes the evidence of PW2, so the PW2 has made out a case during his examination in chief before the court on evidence, on affidavit, on oath, that the amount was handed over to Rama. Where is the connectivity? That amount was paid by Rama. Why the Vinod has not been made? If that document is not there, so why the Vinod has not been made as accused?
Lordship, that is initial stage of investigation, that what police has done, that is.
No, at the time of judgment, court has to consider
Lordship,
with regard to the act of the investigating officer.
Lordship. But Lordship, I appreciate this part. When the PW who specifically said, I have given the entire money to the Ramara
Oh,
for evidence, Lordship. The cross-examination not touched.
not
anything, Lordship.
necessary, not necessary.
And admitting that he has been given to Ramara. No cross-examination, at least one line cross-examination.
Okay,
Online cross-examination.
okay.
It means I am admitting, yes, I have received that amount, and remember that amount, Lordship. And regarding Lordship, last, I will not take much time already, but long yesterday also, Lordship. That on the basis of PW2, 468, 471, 409, oral evidence, not suggesting cross-examination regarding the administration position, yes, I have taken the money. That chain corroboration is there.
So as per your submission, which document is covered, section 468 and 471?
That exhibited document.
Yes, which document?
Master roll, attendance registered, exhibited.
Hmm.
Master roll exhibited.
Correct.
That was used by this person.
Who used?
Lordship.
As per the evidence of the PW2, the list was provided by the PRA and Panchayat.
Lordship.
If the Panchayat has provided the list and the person surveyor has made the list, whether he has put the document.
What that is the.
It is not the case the Pradhan has given the name of Krishna Rao and but the surveyor has given the name of Sumit Karmakar.
I have some duty. I blindly cannot say that yes, somebody was not one.
It is not the case. Panchayat has given some name to Mr. Ramarao, but the Ramarao has ignored that
Lordship.
and has put the other person's name and shown the receipt of the amount.
Time is 134. Plus, we should say the
So
prosecution.
34, that's why if the 34, why the agriculture employees have been left out?
It is. But kindly serious. Blindly being a son by government school or see Panchayat Pradhan is a political institution. If I name somebody who has not worked it, yet placed to the surveyor, rather blindly I cannot. Some inquiry.
Okay, which, what document further you want to rely?
No document.
No document.
That part,
Okay.
regarding that part and first concurring finding. I will go to the entire trial court judgment. All the witnesses concerned have been scrutinized well. Thereafter, evidence on record was also gone through by the trial. And the applicant was also entire into scrutinized, gone deeply into the merit of the case. So regarding concurrent finding lordship, regarding merit of the case, I say this special application is
Who is the Sunil Kumar Biswas? Sushant Kumar. No, Sushil Kumar, because this attendance register, exhibit 26, as entirety. Correct? It is entirety. Now kindly come to the page 23 of the attendance register. That is exhibit 26. At the register, I don't think you will having that. It satisfied the villagers of the laborers mentioned in the attendance sheet for the period so and so, so and so, so and so, so and so have been engaged in the excavation of the work of MI pond identified by Mr. J. N. Sigdar and Pradhan. Where is the signature of Rama Rao?
But for the custodian, the custodian have some duty,
Okay.
have some duty, being a government staff.
Okay. Any further?
First with that, let's look at something. Very clear to the right.
Page 56 are the charges. When has talked about 460 and 471. The charges, page 56. The first head of charges. Porting of the activities.
Page 56.
Page 56 of my petition. This is the first two heads of charge.
Yes.
Page 56, that you forged a certain document with acquiescence wrong.
Yes.
That is 468.
Yes.
And then second head, use the certain document that is a master roll. 470.
Yes.
And the next charge is at page 58. This is against me. 409, that you were entrusted with the property,
Yes.
the money. And the third charge is at page 68.
Yes.
This is against the Pradhan.
You, Sushanta Biswas.
420.
The
So-
page 58 is against you and page 56 against you and Mr. Pradhan.
Yeah, and page 60. Page 60, 420, the money part is only the Pradhan.
Correct. Money,
So
money.
there was no charge against the particular money.
Correct.
My friend is saying money.
That's why I-
That charge only was not there, number one. Number two, the charge of entrustment at page 58 cannot stand because of that missing link. Then the money came to me. Now for this, I want to pause for a moment. My learned friend is saying admitted position that the money was taken, that this link document is not there. Kindly take up the LCR once again. Let us see exhibit 28 for a moment, page 95. Page 95, exhibit 25.
page 28.
Page 95, man.
95.
Exhibit 20. to the letter dated 14 November 2008.
Yes.
Exhibited by the prosecution document. What does it say? No specific order or receipt was there. This is the case of the prosecutor. Not that document was there, it went missing. That was not the case of the prosecutor. This is their document. Therefore, if it is the admitted position of Exhibit 28, there is no order or receipt, the money never came to me. Therefore, this charge at page 58 cannot stand because there is no document to demonstrate entrustment to me.
Yes.
And number three, and most important, the charge that is framed of 468, 471 forgery.
Yes.
They are saying forgery of acquittance roll
Yes.
and master roll, which is the signatures. The villager said, this is not my signature. My lord, kindly see very carefully here what is the case. That I forged a document. But it is no one's case that I touched the acquittance roll.
That's
Only attendance register. Now, attendance register, I cannot forge something unless it purports to be something else. The acquittance roll. So why I'm saying this, if we see the forensic report says the handwriting of attendance register is mine. The handwriting of acquittance roll is not that of villagers. But it does not say
Who prepared
it is mine. If that thing is missing, this charge also. If these three things are going my lord, then after that, the only other point I have to say at page 73 of my application, I learned that is referring to PWC. Kindly see how the situation is twisted. Page
Yes.
73, cross-examination, third line. Ramarao was assigned to look after. Graduate civil engineer was assisting him. And this man was also supervising the job. Now I am asking myself, the surveyor is the lowest in the line. Whether graduate engineer, soil conservation assistant, assistant director, whether they will assist surveyor or the other way around. This is made clear by the document of the prosecution, Exhibit 8. Because when my learned friend read out Exhibit 8 just now, the order assigning me, Exhibit 8 is very clear. I am to assist them in their work. It is not the way that
You have-
is portrayed. These are my only restrictions.
You give short notes. Tomorrow you will give. You give. Hearing concluded. The petition director to file short note by tomorrow. Let the matter fix tomorrow.
So it is ready, but page number.
The petition director file this short notes by tomorrow. Release the matter tomorrow as to be mentioned only for filings by the petition. You will find even
Yes.
by the parties. Both by the-
Then the content and notes and other. Otherwise, it will be direct text.
What you mention tomorrow, we may over there. You notes there. Yes, next. Yes, call the matter. Five bail application. ठीक खत्म. For not today, for not. Yes. Where's the notification? Have you got the notification? Where is the inventory? Give, yeah. When the inventory was done? No, inventory, when the inventory was made. Huh? What is the date?
August
24th of August,
2020.
24th August 2024. Correct.
Correct.
And when the material sent to
Send to, I will come, I will put it in. Date to, it is on 25 September 2020.
25 September
2024,
2024. When they received,
received on 25 November.
where from the material was sent to the CFSL?
21
Where from the material was sent to the CFSL? Where from? It is from the police station or it is from direct from the?
No, who- See, that's later it speaks 21 September 20 was by the SP address to this region.
When?
25 September.
25 September.
2020. Because 24 August 2024
Sampling was done.
sampling.
Inventory was done.
Inventory done.
Correct. Then
August
Ah.
and September 25.
September.
1 month.
After 1 month you have sent.
1 month.
Hmm.
And 21 month.
Correct.
Then the report was prepared from 15 November 2024 to 21 November 2020.
What is the date of the report?
Date of the report is date of the report is 21 November 2020.
21st November 2020.
20
It was prepared.
PPH.
When you
And
received.
examination done from 15 November.
Okay, no problem. Prepared. Then when it was come to you,
Yes.
it was come to you or it was come to the.
35 and 35 November.
When it was come to the SP.
But document is not there, no, see. But on the next day,
So it was sent to direct to the IO. The report was directly sent to the IO. The persons are conducting the trial and maintaining the CD, sir.
on the same next day, charge sheet filed with this.
When the report was sent to court or it was sent to the IO, whether any report was sent to the magistrate?
No,
No.
No.
Okay, give the CD. Record a note.
I was
Give the CD. The petitioner has filed the present application. No, this is an application under section 483 of.
Lordship, may I cite it on that minutes? You can.
So,
That 4 bail application was heard. Thereafter, that incomplete CFS even though charge sheet was filed.
correct, I know.
Lordship, that,
Justice Basar, August. And this is an application under section 483 of Bharatiya Nagrik Suraksha Samhita 2023, praying for bail in connection with FIR number. You persons are not mentioning the FIR number in the cost title. 81 of 2020, 2024 of PS Bamflat under section 22C of the NDPS Act. Pending before the learned Special Judge NDPS Court at Port Blair, being a special case number 34 of 2024. Counsel for the petition submit that the petitioner was arrested by the police of Cooperative on 24th of August 2024. On the allegation that a commercial quantity of narcotics have been seized from the possession of the petitioner. Counsel for the petitioner had brought the attention of this court to the seizure memo. Which reflect that this alleged seizure was made at 20:35 hours. Which the petitioner has got the and the petitioner also relied upon the report under section 42 of the NDPS Act, wherein the station house officer has informed to the higher authority for conducting raid. He submit that as per the FIR, the information was received on 18:30 hours. 18:30 hours. 18:10 hours. 18:10 hours. And subsequently a report was sent, information was sent to the higher officer, but that does not reflect at what time it was sent to the higher authority. He has stated that as per section 50 of the NDPS Act, it was stated that the information was received at 18:10 hours. But in the notice under section 40, it was recorded that the information was received at 18:30 hours. 18:30 hours. Counsel for the petition brought to the notice of this court to the charge sheet filed by the police authority after completion of the investigation, and submitted that as per the charge sheet, the independent witnesses were arrived at 18:50 hours, and about 1700 hours, the SHU of the concerned PS, comprising of the gazetted officer, had reached the place of occurrence, and the alleged seizure was made. At 20:35 hours. But in the charge sheet, it is mentioned that at 805 hours, the informant pointed out about 20:05 hours. 20:05 hours, the informer informed about the person who was coming by a walk towards the Hotan jetty to the bus stand. By referring the said documents command, the counsel for the petition submitted there are several contradictions with regard to the timing of the alleged offense and with regard to the seizure of the alleged narcotics. The counsel for the petition further submits that in the present case, altogether 7 accused persons have been arrested. Out of 7 accused persons, all 6 persons have been released on bail. But these persons have been languishing in the custody since the date of arrest till today. And till date, no charge has been framed. He further submit that the petitioner has also filed an application for examination of the 3 witnesses who were the material witness of in the case at a time. But till date, no charge has been framed. And in the meantime, one of the accused who have been released on bail has filed an application for discharge. And just said the case has not been proceeded, and most of the charge not yet been framed. Thus, there is no chance of completing the evidence at the earliest. Per contra, learned counsel for the petitioner further submitted the petitioner is the only bird bread earning member in the family, having two minor children who are school going. Due to detention of the petitioner, the family of the petitioner are facing great difficulties. He further submitted that the petitioner is a permanent resident of this island and born and brought up in this island, and as such, there is no chance of absconding of the petitioner from this island. Per contra, the learned public prosecutor submits that the six accused persons have been indicted on bail as nothing was seized from the said accused persons. Only the said accused persons have been arrested on the statement made by the two accused persons. Full stop. He submitted from the present petitioner, the commercial quantity of the narcotics have been seized. And as per section 37, the petitioner has not made out any case to come out from section 37 of the NDPS Act. And as such, the petitioner cannot be released on bail. Full stop. Mr. Karmakar, an advocate, further submit that the immediate after the disposal of the application filed by the co-accused for discharge from a charge will be framed and the trial will be commenced. He prays for rejection of the bail. Any further submission?
One person, as per paragraph 14 of the notification.
Para-
Within paragraph of the notification.
Hmm,
But yes, please, as per the notification, continue to.
hmm, hmm.
The chemical exhibition submit its report to the court of magistrate with a copy to the investigating officer within 15 days from the date of receipt of this sample. So it is the duty of the safe person to, but within the record, within a time, I have sent it across. And this violation of rules, violation of rules cannot overrule the statute of the law. The special act cannot overrule the statute. It can be taken at the time of trial also.
Leonard, full stop. Heard the Leonard Conley. The public prosecutor has relied upon the judgment passed by the Honorable Division Bench of this court in the case of Ananta Burman versus State of West Bengal in CRM within bracket NDPS 1617 of 2024, dated 2nd May 2025, wherein the Honorable Division Bench of this court has held that mere not filing of the supplementary charge sheet along with the chemical examination report will not, the petitioner will not entitled to get the bail.
Para 17.
Get the bail. Heard the Leonard Counsel for the respective parties peruse the materials from the court. The petitioner was arrested by the police of PS Bamboo Flat on 24th of August 2024 on the allegation that commercial 1,280 gram of heroin was seized from the possession of the petitioner. Subsequent, during the investigation, the police have arrested seven accused persons, August 6 accused persons, and subsequently they have been released on bail and nothing was seized from the possession of the said accused persons. This court finds that the alleged narcotic was seized by the police by way of seizure memo on 24th of August 2024. And the inventory was when the inventory was made.
24th August 2000.
And on the same day, the inventory was made. And so did the inventory was made. Inventory of the seizure was made. But the narcotics was sent to the CFS only on 25th of September 2025. And the CFSL has sent the report on 21/11/2024. 22. As as per the NDPS rule, notified on 22nd and 23rd of December 2024, as per rule 13, as per rule 13 within bracket 3, no, as per rule 14, the chemical laboratory shall submit its report to the magistrate with the copy to the investigating officer within 15 days from the date of the sample. With the date of the sample. In this case, this could find that after the period and full stop, the prosecution failed to show that whether immediate after the inventory, the material was directly sent to the laboratory in terms of rule 30 of the NDPS. Of the NDPS. क्या हुआ? NDPS. This also finds that the report was not sent to the jurisdictional magistrate along with the sample, along with the chemical laboratory report has not been sent to the magistrate directly by copy to the investigating officer. But otherwise, the report was sent directly to the investigating officer. Instead, the report is report sending to the magistrate. Sending to the magistrate. This could also find that the petitioner is in custody since 24th of August 2024. One or the other reason the case has been adjourned, and till date no charge has been framed. It is fine from the record, one of the accused persons has filed an application for discharge that has also not been disposed of. Considering the above, this could find that during the investigation, the investigating officer has committed several errors by sending the material, the narcotics to the CFSL for obtaining report, and the CFSL has caused delay for sending the report to the London magistrate, and the CFSL also not sent the said materials directly to the magistrate and send the said to the investigating officer. The Learned Counsel for the petition have also raised certain irregularity with regard to the time of the seizure and with regard to the information to the special officer and with regard to the issuance of notice under section 42 and section 50 of the NDPS. Considering the above, this court find that the petitioner has made out come out from section made out a case to come out from section 37 of the NDPS Act. According, the petitioner may find bail of rupees 20,000 two sureties. One surety must be a local. Police if on bail, the petitioner shall appear before the PS Chatham on alternative day, and he shall appear before the trial court on each and every date of hearing, and he shall not leave this island without the prior permission of the trial. Babu from, chapter niche Babu. Huh? Yes. So inventory, you were not given the date of inventory. 26th?
August.
26th.
But I have been for the petition.
Yes,
480.
yes. What is the quantity?
Quantity is commercial quantity.
Huh?
It has to be 0.9.
Hmm.
The commercial quantity.
Hmm. What is the ground? What is the ground?
First ground, kindly see when the FIR was chopped off. Not the FIR hearing was chopped off on 1st of September 2024. And the sections 11 and the FIR is under section 22B. This will not be kindly keep this particular thing on record. Now, may Lord may kindly come to the seizure list, since my Lord is already having the baseline. But may kindly come to the seizure list of this particular accused, Raju Bolta.
Where is the CD?
But yet, first person arrested was one Mr. Sanjeev Kumar Halda. He was arrested with a quantum of 10 grams of methamphetamine and a case under section 22B was.
What is the name of this petitioner?
Is Raju Goldar.
Okay.
They say that when we come to the charge sheet, they say that the first,
How many accused persons?
there are 3 accused persons, out of which 2 have been granted bail.
Nothing was seized.
No,
There.
one accused, it was the medium quantity.
What is Sanjay Kumar Halda?
Yes, Lord.
Sanjay Kumar Halda?
From him, 10
Ah.
grams.
Okay.
Lord, to kindly come to one by one. I'll come here. Lord, to kindly come to the seizure list.
Correct.
Lord, seizure list of Raju Goldar.
Hmm.
The date of FIR is 1/9/2024 and it is 78 of 2024, and kindly see the sections below. The sections are section 22C oblique 29 of NDPS Act.
Where from you are reading?
Lord, the seizure list below.
See the list of Raju Goldo.
Seizure list of the Raju Goldar.
Correct.
Lord, kindly come on the top right side below.
FIR 78, acha, 22C plus.
22C oblique 29 of NDPS Act. And
Yes.
this date of seizure is on 16/9. Now, my lord, there is also an application filed by the concerned IU before the special court asking for incorporating these 2 sections. My lord, kindly come to the date of application. Now, the date of application for incorporation of these 2 sections are on 17th of September, that is after the seizure was effected. Look, there is an application. You have to kindly come because in the CD, the date on which the accused persons were produced, on that day, the IO makes an application before the trial court that these 2 sections are supposed to be invoked.
So earlier it was 22C.
22, on 22B, Lord, because it was a medium quantity.
Where is the FIR? Where is the FIR?
Okay.
Yes.
It is 22B, my lord.
Hmm.
Whereas in the seizure list, they say that it is under section 22C oblique 29 of NDPS Act, and this particular seizure list, as per that, it was prepared on 16/9. Now, the application that was forwarded by the concerned IO before the learned trial court is of 17/9/2024.
Just a minute, just a minute. This FIR was chalked out under section 22B on 1st of September on the basis of the Caesar memo.
On the basis of the seizure
memo.
effected from Sanjeev Kumar Halda.
Sanjeev Kumar Halda is the first accused.
First accused.
That's why I'm telling.
First accused.
First accused is Sanjeev Kumar Halda.
Yes, no.
Where is that? Sanjeev Kumar Halda. Yes. 10 gram.
Particular seizure memo,
Hmm.
section 22B has been invoked because it was an intermediate one.
2 years. 22.
Now kindly come to the seizure list of Raju Golkar,
Correct.
which was effected on 16th of September 2024.
Correct.
And in that seizure list, it has been mentioned that the sections are 22C/29.
Correct.
Lord very well knows that the sections can only be altered after an application is moved and after getting the permission of the.
Not necessary.
Not right.
Not necessary. During investigation, it is found that some offense has been made. Under this, it is not necessary.
But the IO has made an application.
Maybe made an application. Yes. When the seizure was made on 17th of May, 16th of September.
16th of September, the seizure was made.
Correct.
Kindly come to the FSL report.
FSL report, where is?
Yes, sir. There are two FSL reports. I am concerned with the FSL report number 226.
226.
Yes, sir.
Yes.
Remember, kindly see the date of seizure was on 16th of September. The date of receipt here is on 11th of October. After a period of say around 25 days.
No, that
No date of receipt is mentioned.
correct. Date of receipt 11.
11/10/2024.
2024
And
and
seizure was effected on 16/9/2024.
examination.
The examination was done again after a period of say around 15 days.
Correct.
That is on 25th of October 2024. And the report is dated 29th of October 2024, which was not sent directly to the magistrate, rather it was sent to one DPS, not even to the IO concerned.
Yes. Yes.
Now, look, as per the notification with regard to the rules of NDPS storage, seizure, sampling and disposal, my lord, may kindly come to section 13, my lord.
Yes.
That the samples after being certified by the magistrate shall be sent directly. So kindly come to the date of inventory when the inventory was prepared. The date of inventory, it was prepared on 17th, my lord, 17th of September 2024. There is no awareness as to where the implementing articles were kept lying from 17th September 2024 up till the date when it was sent. It was never sent directly to the concerned officer from the magistrate.
Okay.
And the language is shall. Look, again, I am reading for the sake of the samples after being certified by the magistrate shall be sent directly to any one of the jurisdictional laboratories of CRPL, Central Forensic Laboratory or State Forensic Laboratory as the case may be. Now, kindly come to section 14. Expeditious test. The chemical laboratory shall submit its reports to the court of magistrate with a copy to the investigating officer within a period of 15 days from the receipt of the samples. Here, the samples were received on 20.
9th October.
Yes, Lord. I'm fine. The report speaks. It was received on 11th of October. Lord. They had waited for 15 days. They have overlooked the mandatory provision, mandatory period, within which they will have to cause the examination. They have waited for 15 days and thereafter Then they have sent the report. But this is the second round.
Yes.
Now, for the third ground, let me kindly come to the arrest memo here. Arrest memo of this accused person. Correct custody memo. Custody memo.
Yes.
Custody memo, point number 4. below. The grounds of arrest, there are point number 4. below. The grounds of arrest, nothing has been given.
Raju Gold,
Yes, Vinod. Not even a single tick is there.
custody memo, arrest memo. 4. Serial number 4.
From the custody memo, serial
Yeah.
number 4 में kindly please give me the-
Proper investigation, prevent the accused, prevent the making, ensure the
Yes.
court violation. Nothing. Because this is the old format.
Yes,
There
all for.
there must not be any.
Settled principles of law.
Hmm.
A separate grounds of arrest will have to be communicated in writing to the accused person, my lord, which has been observed by this honorable court.
Hmm.
Lord, in this particular judgment, Sudhar Mangal versus State of West Bengal.
ये उसमें जजमेंट में कॉपी गया थे।
Should I just read it and then?
पहले वाला फाइल में देखो बेल वाला कॉपी गया, एक दो जजमेंट था। Yes, yes. Yes.
It comes to.
But Mr. Milongo, before referring this, now the Supreme Court, the matter is before the full bench, whether it is the prospective effect or retrospective effect, because that's why you're seeing you have been arrested on September, 1st September.
Yes.
And now this is after 25th of February 2025. So now the matter has in the full bench of the Supreme Court to decide is given the retrospective effect or prospective effect. So that's why it is. So that is pending before the question was raised in one of the bench and it is sent to the chief for. So whether this court can decide, because you are after, it is before the 25th of February 2025.
Then if I don't give much of importance to these grounds of arrest, not one thing is very clear. That the prosecution has not followed the laws which is rule, which is mandatory, which they will have to follow it.
Or under section 37 is special and violation of rules can be taken during trial.
But problem is, Mr. Sumit, you are telling me if the in Andaman you are not proceeding with the trial, how far the persons will be detained in the custody? If taking the view of the 37, I find that for this last 1.5 years, how many cases of the NDPS has been disposed of? Show me. Otherwise, I will issue the so to the learned judge who is holding the NDPS case. He is rejecting all the bail application, but he is not disposing of the matters. Not the police is doing. Taking the inventory and going to the Malkhana. This is the way.
Notification 2000 to the office of Tigar in law.
So, why you are not sending directly to the CFS or CFS is by the side of CID?
It will be said to the magistrate directly as per notification.
Then,
That is, I have circulated this one.
okay, we can understand it's a Rangat, but you can directly come to the Blair. Why you are taking the seats to the inventory to the police station and keeping that for the 1.5 years?
Myself, I have circulated this all person. Regarding notification, follow it.
They don't know.
But regarding.
And every day you are making the Facebook of the all police personnel conducting the.
Regarding grounds of awareness, everything we are taking more than 8 jobs.
Tell you know And presiding officer, if it is not able to dispose of the why, how many cases been disposed of for the last 1.5 years? When he has taken the seat? Can I record all these things?
That's.
I will record, I will. But the something has to go to your.
Yesterday, this notification, I was, I got circulated with a letter to all concerned, we followed all these things out of the court I submitted. Yesterday itself, when I.
2022, this has been notified. This is an application under section 483 of the Bharatiya Nagarik Suraksha Sanhita 2023 for grant of bail in connection with FIR number 78 of 2024, dated 1st of September 2024. PS Rangat under section 22 within bracket small b slash 22 is within bracket small c slash 29 of the NDPS Act, pending before the learned special judge. NDPS court. NDPS court. NDPS court. Being, what is the number? Case number. Then you will be in trouble. Being NDPS case number, being special NDPS case number 21 of 2024, pending before the, pending the special case number 7. Counsel for the petition submit that initially one accused, namely Sanjeev Kumar Haldo, was arrested by the police of PS Rangat on 1st of September 2024 for the offence under section 22B of the NDPS Act. And during the investigation, the petitioner was arrested on 16th of September 2024 on the allegation that a commercial quantity of narcotics have been seized from the possession of the petitioner. Full stop. Counsel for the petition submit that since the arrest, the petitioner is in custody. The other two accused persons who have been arrested in the instant case, two accused persons have been already been enlarged on bail. But this petition has been denied the bail on the ground that the alleged quantity is commercial in nature. Mr. D. Ilango, an advocate appearing for the petitioner, submit that the police has initiated the case under section 22 within bracket small p of the NDPS Act, but subsequently at the time of arrest of this petitioner, the police has invoked section 22 within bracket c slash 29 of the NDPS Act, 1985, without the order of the court, and subsequent addition of the section, the investigating officer has played for addition of section. Mr. Ilango further brought to the notice of this court, so the inventory was made on 17th September. When the inventory was made?
It was made on the next day, 17th.
On 18th September. On 17th September 2024. But immediately after the inventory, the investigating officer failed to send the seized material directly to the concerned laboratory for obtaining report. Instead, it was taken back to the police station and was sent to the CFSL. Sent to the CFSL on 24th by a letter dated 24th September 2024. But the laboratory has received the same 11th of September 2024. That is about 1 month after. October, 11th October 2024. That is about 1 month after the reverse. Mr. Ilango further submit that this laboratory supposed to send the report within 15 days from the date of receipt of the materials. But the laboratory has sent the report to the investigating officer on when it was sent
29th.
on 29th of October 2024 directly to the investigating officer instead of sending the same to the magistrate. Good stuff. Mr. Ilongo further brought to the notice of this court to the arrest memo and submitted that the petitioner was arrested on the 16th of September 2024, but no reason has been, the ground of arrest has not been assigned to the petitioner at the time of arrest, and as such, the investigating officer has violated the provision of the Constitution of India. Full stop. In support of his submission, Mr. Ilongo has relied upon the judgment in the case of Vihan Kumar, Vihan Kumar versus State of Haryana and others, passed in SLP criminal number 133. It is been reported. Reported, I think. I am having criminal number 13320 of 2024. 2024, wherein the Honorable Supreme Court held that if the arresting officer failed to assign the reason for arrest in the arrest memo, that is violative of the provisions of Article 52 of the Constitution of India. Full stop. Mr. Ilongo submits that since the month of September, what is the stage of the trial?
The charges have been paid.
Counsel for the petition submitted, though the petitioner was arrested on 16th of September 2024, and since then the petitioner is in custody, but till date evidence has not been commenced. He submits that it is not possible for the court to dispose of the application, dispose of the case as early as possible, and as such he prayed for bail. Per contra, London advocate, per contra, London public prosecutor, Mr. Sumit Karmaka, public prosecutor, submits that the narcotics seized from the possession of the petitioner is commercial in nature, and the petitioner has not made out a case to come out from section 37 of the NDPS Act, and as such he cannot be granted. He cannot be released on bail. Mr. Karmaka submits that the rule is not a mandatory, it is a directory. And as such, on violation of the rules, the petitioner cannot be released on bail. Mr. Karmaka further relied upon the judgment in the case of Ananta Burman versus State of West Bengal, passed in CRM NDPS 1617 of 2024, dated 2nd May 2025, and submitted that mere filing of the CFS report by way of supplementary charge sheet subsequently will not entitle the petitioner to release on bail. So, thirdly, learned counsel for the respective parties peruse the materials of the report. As per the seizure memo and as per the case made out by the prosecution, the commercial quantity of the narcotics have been seized. The petitioner was arrested on 16th of September 2024. An inventory was made before the land magistrate on 17th of September 2024. After this inventory was made, instead of sending the materials to the directly to the FSL, the investigating officer has taken the materials after the inventory to the police station and had sent the materials to the CFSL after on on 24th of September 2020. The CFSL authorities, instead of sending the report directly to the magistrate, copy to the investigating officer, have sent directly the report to the investigating officer instead of sending the same to the magistrate. Sending to the magistrate. Police. Mr. It also found that the petitioner was arrested on 16th of September 2024 and a custody memo was prepared. But in the custody memo, no reason has been assigned. Nothing was shown that the reason was assigned to the petitioner with regard to his arrest. Considering the above, this court finds that the petitioner has made out a case to come out from section 37 of the NDPS Act. Accordingly, the petitioner may find bail of rupees 20,000 two sureties of rupees 10,000 each. One surety must be local. Full stop. If on bail local, with the satisfaction of the with the satisfaction of the land judicial magistrate at Mayabandar. Full stop. If on bail, he shall report which be Rangat, where he resides. Is residing the way. If he will attend the police of PS Hudway on every alternative day, as he is the permanent resident of Hudway. And whenever he intend to go to the Hudway when he intend to go out of from the Hudway to attend the court at Mayabandar, he can inform the station house officer as Hudway. At Hudway, and with the permission of the assessor, he will leave the place. Policeman. He shall appear before the London Trial Court on each and every date of hearing, and he shall not leave the garden without the prior permission of the trial court. CRM senses. Well. Next. Yes.
Here, intention was allowed very prior. And this was understand that no repair calculation of the property. When they started calculation method, I take out an application under section 151 they file their written objection, they denied that they are not carrying any construction, they are not violating the order. This is the specific denial. So my lord, just passed an order, my lord, can you see that way?
Yes.
The court say today is fixed for passing of the order has been said. My lord, can you see that paragraph which stand of the advocate for the defendant also files suit set of written objection containing particulars of the act that when the original property was leased out to the defendant, it consisted some structure more. Now the planting has become the application on the ground that the over their superstructure, the repair, renovation, and alteration by the defendant is being carried out. Which is the character of the property paid for rejection. I also against the application document and accept the Indian record specifically the order of the court. Ask London advocate for the planting to not explain as to how to verify for what extent the construction of repair work is being conducted over the existing superstructure. I think at this juncture, because it is potent and comprehensive report regarding the present scenario of the problem, court is not in a position to pass the order. Now, my lord, we find that when application was filed under section 151, we filed it along with an application photograph, and immediately, even after filing, when the matter was fixed for hearing, they further pursued the construction with I filed one more application where brought out all the photographs will clearly reflect that construction is.
Still the construction is going on.
Yes, my lord, this is my.
But you are not filing.
On, my lord. When there is an order of the court, the intention order of the court said no further construction till the disposal of the case. Then the court has to consider that the order of the court should not be quoted by any of the parties.
Correct.
And when one application is filed, the court cannot reappreciate the argument of the parties and arrive to a conclusion. The court has to see that the order ought not to be quoted. This could be the intention of the court.
Have you informed the police authority with regard to first?
Yes, my lord, this is, we have said in our meetings also. My lord, that we have made complaint. to the
But
police
you,
authority.
you could have been one some, they have filed the written objection, you could have made an application for appointment of commission. Why you not done so immediately?
The situation, my lord.
Where it is?
In development. There are two parts. There are two parts of these deeds. First part says, so far as renovation, alterations, repair, they need my permission. And the second part of the deed says that says so far as new construction is concerned, no permission is required. Earlier they started new construction. I filed an injunction application, court rejected. I filed this appeal, the court affirmed the order saying that since it's a new construction, it cannot be done. Now, my lord, I can show at page 38, my lord, can we see the part of the lease, which is binding upon the parties, and on the basis of this only the court has arrived in the finding and accorded me an injunction order. My lord, can you see page 38?
Yes.
Not judgment. It says, have the right to repair, alter or renovate the existing superstructure on the site after written approval of the leaser at the lease's own cost and to put up new building at the site without any reference to the leaser. However, this is the condition, the terms and condition of the contract which is binding upon the parties. Well, on the basis of that, I said that they have started construction. They filed written objection. Court, after considering the entire scenario and the facts of the case, passed this injunction order. Now, my lord, whether the court has not duty bound to see that the order of the court is not quoted by
But on the other hand, Mr. Bin, you have to also prove once they are taking, then it is upon you.
then my lord may this coming to my lord, then the commissioner, my lord.
Correct. Then they come, or I will demand this matter, you take an application for appointment of commission.
Then it will further prolong, my lord. When there is an order, my lord, they are carrying the.
Still carrying on.
Yes, my lord.
Yes, ma'am.
Question is complete. As per the, it says, have the right to repair
No,
or.
whatever it, now status quo is there.
That's what the way. The court has passed the order, that there should not be any type of repair, renovation or alteration in respect of infrastructure. That was,
Correct.
they sought for stay of the entire repair, renovation in respect of the entire structure.
Correct.
That was not granted.
Correct.
Because this specifically mentioned superstructure. Which superstructure?
Okay.
While carrying on in construction or repair renovation, the singular word is to superstructure. Let us show which superstructure is there.
Okay.
And don't carry
Okay,
construction.
okay, that's why in that case, what I propose to do, subject to acceptance by both parties, I will appoint one commissioner. I will set aside this order, then let the commissioner file the report before the trial court, and on receipt of the trial court.
Yes, that can be done.
It should be specifically, it should be mentioned that when defendant is carrying out any construction in respect of superstructure.
There is the interim order, there is the injunction order.
That is the problem.
71.
Where is the injunction order?
Page 70.
Because it is on that there is a problem with regard to the.
That's why where is the interim order?
Page 71. Page 70.
You will become, but to find out, how you will find out.
Alteration, innovation of existing superstructure.
Yeah, existing superstructure, one singular word used, superstructure.
My lord, I will.
I'm there, I will make my argument. In the schedule of property, they have mentioned number of things. And they sought for interim order in respect of the schedule of property. Where there is a double-story building, single, nine single-story building, number of things are there. Court rush act interim order. The court specifically stated there is no renovation, renewal and how it is carried out in respect of the superstructure.
Correct.
How the commissioner is going to identify that superstructure? Whether this court can direct that which superstructure is going to be, should not be dependent. There is no description. And moreover, the motion may kindly come to section 151 application. In that application, anywhere it is written that superstructure, I am repairing the superstructure, that is written. You will not see the sentence there. That this is the superstructure, I am carrying out that superstructure, which the court has intended to do. Nowhere it is written. And that 150 application is silent. He wanted, he was taking advantage of the order. One said, entire thing is solved. You know, just one background I want to make. When he moved the application, he said, asking for an injunction in respect of any construction of the property, that application was rejected. It went up on an appeal. He went for an appeal. That was also rejected, and it was said that the petitioner, the defendant, is entitled to carry out new construction. It was already there. But so far as repair and renovation is concerned, for that particular purpose, I have to obtain consent. Then he filed an application for the trial that there should not be a repair and renovation in this actually not considering flexibility for expansion, that superstructure there should not be affected. Now, let him identify the superstructure first. Thereafter, the next can be appointed. How this court can identify the superstructure? There are many structures upon that structure. As per the schedule of the place, it said there are so many structures. So how will we identify?
Yes.
Superstructure. Why not we can see base?
Yes,
Base
certainly.
38 clearly states that the right to repair, alter or renovate the existing superstructure of the sign after written approval of the lease. Talk about this superstructure schedule, page 90. The schedule of the problem.
90, 90,
19. This is the schedule of the problem.
correct.
Now, my lord, which are in existence. Structure which are in existence for the purpose of carrying repair of the said structure, they require permission. So far as new construction is concerned, they did not require any permission.
Yeah.
My lord, my management says that earlier when they started new construction, I filed an application which was rejected, I filed an appeal. My lord, I have closed the copy of the appeal. My lord, can you see?
Yes.
It starts from page 59. My lord, can you see? Page number 4, then page 6 of the order. Regard first, because A of the lease deed in question, I try to find that for basic construction permission of user is not required. But in case of repair, alter or renovation of the existing superstructure on the site, permission is required in writing from the branding. My lord, the structures which are standing are the superstructure. Now, when Leonard friend is taking technicality, no, everybody knows that this is. My lord, the schedule.
Structure has to be described there.
My lord may consider, can you visualize the situation? So far as new construction is carrying, my lord may visualize the situation if new construction, if I take any hypothetical objection, then it cannot be sustained. Because new construction, they are having the right to carry new construction without the approval.
Yeah.
But so far it's existing.
Yeah.
Then what does this clause mean, my lord? This renewal, repair and alteration in the existing plot, existing building, ought to be made consent of the user.
Yes.
And therefore, the technical objection which my Leonard friend made, not the court has to approve the
In respect.
not granted, therefore I will.
No, you have not challenged that.
No, with regard to madam, page number 19 of this application, schedule of property.
Yeah.
Schedule of property with regard to this landed property, one is 1.63 hectares, another is 0.30 hectares, and these are the two properties. 63 by 1, 63 by 2. Schedule of property. Now come to the structure A to I.
Yes.
A to I. These are the structure.
These are the structures in that.
Yes,
Exactly.
these are the structure. So this structure is to be read with A touch. A touch. I.
If that is read, if the intention of the learner trial court by disposing of the injunction application was to give H along with the schedule of property, the injunction could have been granted in respect of the schedule of property.
No, schedule, that's in the schedule of property consisting of total land. Total land. And now, total land, in the total land consisting of this A to I are the structure.
Structure and private edge. He is not mentioned.
Okay, whatever it may be, but now, but when you come to the appellate court order,
Superstructure.
correct, super, then taking that superstructure has taken into 8H. 8H, 8H. Yes,
But not schedule of property.
not central. Yes, 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 I am there only.
One number of cottage,
Ah,
9 members of single story cottage, 10, 11, 12, 12 plus 7, 19, 19, 20, 21, 22, 23, 24. Practically 24 structures are there. Your 8H says superstructure, not superstructure. Yes, because this is very important because you should kindly consider one thing.
yes,
In the schedule of property, whether he has said that these are the superstructure. In the place, whether he has stated anywhere that these are the superstructure. How we are going to do
yes,
that interpretation is required of children. Which one is superstructure? That's why I should mention that. What else are they saying from carrying out construction in respect of the schedule of property or suit land or suit property? Had it been so, I could have challenged because they are restriction. The intention of the court was only to restrain me from carrying out construction, total structure only.
Mm.
So I have not challenged it because of the restriction. Otherwise, I would have challenged it.
yes,
You should, it has to be looked into because it in the plane, in one of the paragraphs, it should have been mentioned that in terms of structure which are existing on the land, whether it is mentioned in the plane. If it is mentioned, you should I'm out of the code. I will rely on that here A to H are superstructure. If it is mentioned anywhere. Either in the plane, non-monetary and NDPS that these are the superstructures existing upon the land at the time of existence of the land.
yes,
No other way. So it will be very hard to lordship upon if that superstructure is going to be defined now by including all these A to H A to H structure. Because that particular thing has not been done for the private. What is there is an application for getting clarification in respect of superstructure. But this one should clarify that what is superstructure. Let them file an appropriate application before on a trial court. For getting the clarification. My entire objection.
No, it is even there. I thought it was there written objection. My lord, I had put in my letter, and my lord, can you see in written objection, there is no such written objection, my lord.
I did not say like.
Yes, yes, please come.
Complete my objection is that only.
My lord, can we see the?
Yes. Kindly come to the question.
At page,
Starts from page 99.
ah, 83, 83,
page
84, 84, 83.
83, but can you come to page 84? 84, para 6 and para 8. This is their case, I don't know.
Yes. Kindly come to the. Kindly come to paragraph 3.
Yes,
My complete is that. However, it is stated that the defendant did not carry out any return operation relation to the superstructure as alleged by the plaintiff. Specifically mentioned
ah, that's good.
superstructure. Again and again, because superstructure has to be defined. I am not carrying out any construction in respect of superstructure. Let them show what is superstructure. I will not carry out any construction in respect of that superstructure. That's why I am submitting lordship. And specifically, I have used the word alleged. Because we don't know what is the superstructure. Schedule of property is also silent. Date is silent. Applications are silent.
Okay, Mr. Binu, you do one, I am not touching this order, liberty to file a fresh application if occasion arises and file a application.
If I can find like,
What's the
suppose of doing the paper. Thereafter.
No problem. Because it is correct, if I again they interpret, then they will lose one for, if anything. So let the trial court decide it. So I am not setting aside this order, but giving a liberty to file a first if any application is filed, it is to decided within a period of 30 days. The petitioner has filed the present application, present revisional application challenging the order passed by the London Civil Justice Senior Division at Foot in other suit number 138 of 2015 by the order number 105 dated and 5, wherein the London Mention Judge has rejected the application filed by the petitioner, section 1 filed by the petitioner under section 51 of the Code of Civics. Counsel for the petitioner that there is an order of injunction passed by the Leonard Civil Justice Senior Division, wherein the plaintiff is directed not to make any repair or alteration or renovation in the existing superstructure till the disposal of the suit. This order was challenged. The plaintiff came to know that the defendant is carrying out the repair work in spite of the injunction of all but civil the senior division according to plaintiff identification for direct the prayer for directing the concerned station of officer. The order of injunction passed by the is implemented. There is a dispute with regard to the police. And concept for the defendant submit that clause H of the lease deed. Lease deed stated that right to repair, alter or renovate the existing superstructure on the site after written approval of the lessee at the lessee's own cost and put up new building at the site without any reference to the lessee. See, for the attention of this court to the interim order or interim order passed by the temporary injunction passed by the London trial judge, wherein the plaintiff is directed not to make any repair or alteration or renovation in the existing superstructure till the disposal of the suit. Counsel for the defendant or respondent submitted that in the application filed by the plaintiff under section 151, there is no statement which superstructure the defendant is carrying out the construction. That this court cannot modify or alter the interim order passed by the trial court. Considering submission made by the counsel for the respective parties, this court find that the London Civil Justice Senior Division has rejected the application filed by the plaintiff under section 151 of the CPC on the ground that the defendant and the plaintiff has not shown any evidence or explain how the defendant has making construction over the superstructure. Considering the above, this court not find any illegality in the order passed by the Civil Senior Division dated 24th of June 2025. But however, the petitioner, the plaintiff is at liberty to make a proper application if any occasion arises before the airport, and if any application is made by the plaintiff, from the application shall be disposed of within 30 days from filing of the application. But here, that's why I am asked the dependent. Dependent is restrained from making any construction. That's why I am confused. Disposed of. Again, dependent is restrained. Next.
An order was passed on 20. Reference of the Supreme Court judgment. So my lord has asked them to go to that and come back.
Yes.
So SLP has been disposed of. After the amendment to the constitution has taken place, part 11 P was inserted there. I think that we completely read, they have provided the tenure. Then that's likely. For the entirety of the document, for part, I think what is said by the type of this structure of the tariff. I would brought it up. That the essentially was spending a consumption.
It's SLP.
But what order was? The longest order. Okay, sure. I paid the judgment to the officer because I can't afford to.
So you do one thing, when you're going to, so take the judge. 2 hours you spend on the judge. Come on next.
Maybe, this is for evidence for the being kind of giving question of maintainability also.
So you will find affidavit. Mr. Mohammed Tabris Leonard, advocate appearing for the respondent number 3. And Mr. Rakesh Kumar with what is your good name? So appearing for the 1 and 2. Takes for time to file affidavit in opposition. Let affidavit in opposition filed within 2 weeks. Reply if any have to be filed within a week thereafter. Is the matter before the next available circumstance. Tabris has raised the point of liquidity or the locus of the writ petition in the writ petition. The same will be added at the time of edit. 78. Thanks. So they clean. Yes, next.
I don't very well know this is a government tax they have to do. Now I don't the time to see building bylaws and the regulation. And thereafter this judgment bylaw is very much of and so it. But can we see the definition given in the regulation? Regulation to this bylaw,
Municipal regulation.
principal regulation.
Yeah, yeah, the municipal. You? Municipal regulation. 94. There is no amendment on that, no?
Now my lord, section supposed to define building.
Section 2 supposed to be released.
Building a house or other whatsoever purpose of whatsoever material constructed every part thereof and includes the wall it is well, but does not include a tent or other such portable and very temporary shelter. Well, I am on this one. Now, what they have done, Lord, they have framed building by law. They have omitted this part. And now what is the definition as per the building bylaw? They say building is any structure of whatever purpose and of whatsoever material constructed and every part thereof, whether used as human habitation or not, and include trees, park, roofs, companies, and building service fixed platform, verandas, part of the building or any other affix thereof, staircase, doors, steps, attached, everything has been this part was omitted. My lord has appeared in this matter. My lord, you find that paragraph starts from paragraph number 15, my lord. Even paragraph is paragraph number 8. Apart from paragraph 15, the law has been discussed, issues of bylaws and regulations. Paragraph 18 says, but aside, the second provision
and the authority of the municipality to waive demolition seek compensation as such sum as it will find reasonable. The municipal bylaws has come into under authority of section 160 of the said regulation of soil. So if the party has authority of delegation to make rules and bylaws in respect of any specified matter, the bylaw cannot contain any provision that will detract from the parenting act. So exactly here, they on the basis of this bylaw, order below. Okay. Before the order page 16 says that any constitution can see page 16.
Yes.
Whereas can be reported, it's not reported to understand that agent servant are constructing the building structure on survey number so and so situated without obtaining so and so from the vicinity, and my land is situated more than 12 feet, from this,
Obtaining NOC from Utkrosh.
not before
It is under the
to town.
green area.
By for guide up to 12 kilometer radius that
That is for the building.
that is not abuse of power can be satisfied this order. And the reported
Yes. What you are doing?
We are studying of employee report. Page number 80. Page number 80, not page 2 of our lecture. That part so celebration Durga Puja attend to place the session as the second week of May.
Which paragraph?
Paragraph 6, page number 80.
For the purpose of celebrating Durga Puja, intend to praise second week of May. We started carrying out the temporary shed.
And then of this order.
So when you will remove.
But that my question is.
No, that's correct. I will record that. Will record that, but
Whether the authorities can ask a person who is carrying a temporary construction that you have to carry it and subsequently you have to remove it, they have no authority. Unless and until it comes within the purview of building bylaws. If today, my lord knows very well, because the municipality during the Durga Puja, they even construct temporary shed there. How they can say that? But some of the temporary shed they could. The Lord is saying is. No, I am saying.
then you go and
That it cannot be.
they have given they have stated the Durga Puja. Durga Puja will complete was by 2 weeks, by 2 weeks. I am not here.
Why it can be? Then it will become a procedure, say that because temporary shed.
We may be permitted.
They give undertaking that after the completion of the Durga Puja, we will remove the shade. Because this is security reason, there are certain exceptions are there. This is not a civilian airport. There is a different airport. It's a temporary structure or permanent, it hardly matter. This is only for security reason it has been.
Yes, Mr.
In fact, my lord, the Port Blair Airport, my lord, is listed in the critical airports by the Airports Authority of India, my lord. There may be certain considerations. We may be permitted to file an affidavit, my lord. After that, my lord, it can be decided, my lord.
Chakravarti, this is not it is not it is covered under the judgment passed by the school because your building bylaws is contrary to the regulation.
My
Building
lord.
correct. So I will decide it is not coming under the purview of the building in terms of the section 2.
No, but if because of the closeness to the airport, there is some issue, my lord, kindly permit us to file an affidavit, my lord.
Census suffering for the petitioner has filed the present application challenging the order. Stay order passed by the executive engineer within bracket planning municipal council dated by stay order number 1929 dated 14th May 2025 directing the petitioner to stay the construction of the building immediately until further. Mr. Prem Kumar, an advocate, appearing for the petitioner, submits that the petitioner is not making construction or making not constructing any building and follows the same. Mr. Punya Kumar brought the attention of the court to the presentation submitted to the executive engineer on 5th June 2025 on receipt of the state order dated 14th May 2025 for recording of the state order. In this representation dated 6th of in paragraph 6, it is categorically mentioned that the petition for the purpose of celebrating Durga Puja, the petitioner intend to place the idol of God Durga in the said land, and as said, in the second week of May 2025, he has started carrying out construction of a temporary shed with MS pipes that he has GI and for celebrating. Mr. Vinu Kumar Mr. Vinu Kumar has brought the attention of this court to this subsection 2 of section 2 on regulation 2 subregulation 2 of regulation 2 of the Andaman within the regulation 1994, wherein the definition of the building has been defined. He submitted that as per the said definition, the temporary shelter with the tent or other such portable or a temporary shelter is not under the purview of it. He submits that the municipal council has framed the building bylaws contrary to the municipal regulation. The Vinu Kumar has relied upon the judgment reported in 2015 Calcutta 7 in the case of the K. and Suresh Kumar versus the Lieutenant Governor and others, wherein the court held that the municipal bylaws have come into under authority of section 163 of the regulation of 1994. Parent enactment confers authority on a delegate to make rules and bylaws in respect of any specific matter. The bylaws cannot contain any provision that detract from the parent enactment. In the council for them, Mr. Cooperative and senior advocate preparing for the municipal authority submits that this is being made within the airfield, within the area
Close to the airport, well.
near to the airport. There is some security reason, and as such, he intend to file affidavit in opposition. Full stop. In view of the full stop. Let affidavit in opposition be filed with 2 weeks. Reply if any that will be filed within a week thereafter. This court find that the petitioner has made out a 5% case and balance.
So, my lord, I have one submission, my lord, to make on. My humble submission is, my lord, that this is for temporary structure, I think, for construction for Durga Puja. That is in October, my lord. In 2 weeks, my lord, effectively this will be final order, my lord, if they're allowed to construct. And we can't demolish a puja pandal, my lord. There are sentimental issues also attached to it. So, my lord, we keep it for after 2 weeks, my lord. We'll file our affidavit. Let it come in the circuit after that. They have enough time to construct the pandal, my lord. It's not that they can't construct the.
Now, Mr. Chakravarti, see the totally contraventions of the regulation, and they are not. I don't. What is the height of your structure?
That is the only concern, my lord. If it is endangering the airport, my lord, that is the only issue.
Order it is because see, you are nearby the airfield. It has to be seen with regard to the height of the structure.
Yes.
This is only a terrace.
Then may I just request this, my lord? I'm very sorry since my lord has already dictated the order partly. Let the matter be kept for tomorrow. I will come back with proper instructions and get a report if there is some.
Your authority go and inspect and come with a total, that what is.
Yes, then let it come on Friday in that case, Friday.
As per the prayer made by Mr. Chakravarti, is adjourned, let the matter appear on. 11.
Most grateful.
Clear.
Here, statutory authority has passed an order, I challenge it before the appellate authority has also affirmed the order of the statutory authority.
So it is to be decided on affidavit. Well, affidavit.
But my lord, this matter is not as well maintainable because they went to arbitral tribunal dismissed their, my lord, claim. So they should go in 34,
Arbitral tribunal dismiss
dismiss the claim, my lord.
So, here what happened? I was a member of a cooperative society. 80, there was a notice issued by the society whereby asked members to update their membership for the election, which was shifted to the 2019. Within the time, we did not able to update our membership. Till then, we remain a shareholder.
Still it is going on.
Now, what happened after that? I approached this court. This court did not grant me any relief. I approached the division bench. And the division bench in the judgment, my lord, we find has categorically stated, my lord, this is only for the purpose of election, my lord. I have quoted that part of the judgment of the division bench. I am just placing it. My lord, may kindly come to page number 7. Page number 7, I have quoted the division bench judgment. Accordingly, we direct the word as well as so and so, although much have been submitted by Mr. Kumar regarding the validity of the notice to the effect that no cut-off date should have been fixed and all the members should have been allowed to participate in the election. Election was the subject matter. As and when conducted for production document relating to identity, due notice was published, but unfortunately did not respond as well as within the. My lord, it was confined to election. Now, what happened, my lord, we did not able to update, so we were not allowed. When the election was over, they called for a meeting. We approached. They said that you are no more a member of the society. We filed a writ petition before this honorable court. This honorable court directed me, since there is an arbitrator may be appointed by the registrar of cooperative society, to approach before the registrar of cooperative society. They filed an arbitration application. I filed an arbitration application before the registrar of cooperative society for this membership. He rejected my claim. I preferred a statutory appeal. Once the statutory appeal was over, thereafter this writ was filed. There is no other remedy.
But my lord, once the arbitral dismiss, it should go in 34, my
No,
lord.
arbitrator dismissed and the authority lieutenant governor.
No, then they-
That arbitrator not in consonance with the.
Yes, but not let's say. Dismiss finally the order. Here, arbitration pending.
Arbitration was not pending.
Where the arbitration is pending.
Lieutenant governor said it is not a final order. Whereas the final order was passed, it is part of the application. Final order.
Where is the order of the Reserve Cooperative Society?
My lord, 102. Initially, an order was passed whereby my claim was negated. I preferred an appeal. During the pendency of that, page 102.
Yes.
Passed an order, and the appellate authority, without considering it, saying that no final order is passed.
No. It is under the Cooperative Society regulation.
Yes, 1970.
That has been called as the arbitrator.
Yes.
But if he has passed an order, then it is the appellate authority, it's the lieutenant governor under section 68. Then if the lieutenant governor, then the writ. Yes, Mr. Chakravarti, anything?
We'll file affidavit, my lord. We'll file an affidavit.
Then at council appearing for the respondents.
Well, basically,
Sir, 1 and 2 we are-
appears for the 3 and 4 respondents.
So you also filed an affidavit. Council for the respondents, this for in opposition. Let affidavit in opposition filed within 3 weeks. Reply if any that we filed within a week thereafter, after before the appropriate circuit bench. Next.
For the respect.
Yes.
The petitioner. He made a, he online through online. She filed a,
Where is the impugn order?
at page 17. Have to be seen from the first election level.
Rejection, the request for registration of will.
Well, registration of bill before the sub-register has filed.
Reason has
The
been
reason
assigned,
has
my
been
lord.
assigned in page 40. Kindly repeat what's the reason?
The order itself has
Incorrect.
been assigned.
My lord,
In the order
incorrect
itself.
way.
Correct.
Incorrect way. This was the, by the sub-register. Now, I have filed the, I did before the register. Let me submit, madam, thereafter.
Okay. I will
This
come.
is, again, I have filed the appeal.
Hmm.
My lord, kindly see who has passed the order. Again, 70, the office of the sub-register. Sub-register already rejected my registration. I have prepared an appeal before this register. Now the sub-register again rejected my application. On the ground that I have not produced the land records. In the bill, there is a mandatory to produce the land records. What the sub-register has to see, my lord, it has to be seen that the executor is there, witness is there, it is in the proper form. What contents is there inside the bill, that should not be seen by the registrar, nor the sub-register.
Yeah.
It's not there, look out, my lord, see whether it is a genuine thing or it is not a genuine thing, the appropriate forum will be there thereafter. But registration of bill cannot be.
My lord, first we have to see that who is the executor is the,
Not necessary.
my lord. Any other property we can.
I can execute the will of the Rajnivas.
I can
Who is
say,
the registrar? If the will is executed, then it is the probate court to decide. How you can say, how the registrar will say the land record is not the owner, is not thing. I can give any, if suppose I have a money and I am giving the will. What record? I am having the book. And I want to give the book on will. What record?
But they have annexed the record of rights.
Might
It's not
be the record annex, but
the documents that they have
but they have
annexed,
asked, they have asked.
but it is not connected with the will. It's
They have
not
asked-
connected with that person, the executor.
will is not the right title.
My lord.
And how the sub-registrar has passed this order? On the appellate authority? If it is CS filed an appeal, why the registrar has filed the order?
Something can pass incorrect bill, then again.
Register under the register, no? You,
Deputy commissioner.
no, you have given also the term. It is not the register under, it is, I think, the registrar general.
No, registered is the deputy commissioner, my lord.
Deputy commissioner, registrar general.
Registered. But it's written registered.
Where,
Giving the copy to the deputy commissioner only, my lord. Because kindly seal is there.
sale is but the authority register under the Indian Registration Act.
Registered.
Where the registration act gives the registration? You are having the registration act. If a person executing a will, only the document, the will has to see, not the document. Might be, he may mention the survey number, whatever it may be, not required to see the document. He has to see with regard to the capability of the executant and the witness appeared before him.
That's the intention of
Can you
the.
see the, that's why, can you see the registration act, birth and registration. Come tomorrow. Not today. Come tomorrow. Come tomorrow. You also go through section 17, 17 to 7, section 43. You see what are.
To be recorded and submitted to the appear to the registrar from order for the registrar. Refusing registration on ground of.
Okay, come tomorrow, come tomorrow. Yes, next. CPN.
No, WP, rate petition, fresh.
Can dispose of.
Item number?
12.
I am seeking for an invocus prayer.
Okay.
The prayer is, my lord. There is a laded weight and unladed weight, my lord, in the motor vehicle act.
Hmm.
And if a person carry excessive load, then in such case under section 113, 14, and the punishment is under section 194 of the MBA. My lord, this truck owner association, my lord, they by indulging their own money, my lord, they able to have a very bridge at Calcutta. So that because the condition of the road is very bad, as such, they incurring their own expenditure has constructed it. Thereafter, the director of transport has inaugurated it. Subsequently, my lord, those who are carrying excess load, they are not
Coming on that.
coming on that. Because of that, my lord, excess load has been allowed by the authorities. Under section 113, 14, read with the rules of 2006 of this island. The rule 68 and 82 particularly give the power to the transport authority to have an authorized officer and the police authority to see if any person is carrying excessive. They have to initiate appropriate
So
proceeding.
whether the load is been provided?
Yes, my lord, load in every vehicle. I have enclosed those, my lord.
Load is provided.
Load is provided, unladed and laded load is provided. If my lord kindly come to, I have enclosed several. My lord may kindly see from page 22 onwards.
Acha, gross weight.
Yes, gross weight.
Or unladen weight.
Unladed. So my lord, a person cannot exceed the gross weight.
Other than the.
Yes, sir. So my lord, we have made representation before them. This is, my lord, this is the law. This is their work. We are compelled to come to before this court.
We're abided by the law, but we don't have, these are rules, under provided.
What doing? The unleaded, if the vehicle met with an accident, what will happen?
No, but our contention is that we are doing the waiting thing, weightage.
No, he's not telling that not allowing, but if some of the vehicle is
Yes.
allowed to without any weight.
Now we shall curtail those vehicles, my lord, we shall take action.
No, they have made a representation, my lord. It can be disposed of with a direction to decide the representation, my lord, after giving them a hearing. So that they can make their representation whatever they want to say and if whatever steps are required to be taken after that.
Light of the provisions of the Motor Vehicle Act and the rules framed by them. More specifically, I have reproduced those sections in my writ petition also. If my lord sees from ground number 3, my
But
lord.
this is in the nature of a PIL, my lord, in that case, my lord.
Ground number 6.
Who are you, Mr. Binu
I
Kumar?
am the Andaman Nicobar Truck Owner Association, my lord. We have constructed it.
So why, how, acha, you have constructed?
We have constructed it, my lord. The director has opened it. Opening ceremony was conducted by Director of Transport. And thereafter, for 2-3 days, my lord, everybody was were using this.
But how the rate petition? And
My lord, we are the affected party on the basis of their assurance we have constructed actually, my lord, by incurring 57 lakh rupees. And because of that, road condition from Jirkatan to my lord, northern middle Andaman is worse. And this is one of the factors, my lord sees 2018 Supreme Court judgment, where the Supreme Court said, because this is a factor, my lord, excessive weight. Because of that also road condition, bridge condition are being deteriorated, my lord.
My lord, it's the good, my lord, cause which has been espoused. Kindly permit my lord, consider directing the authority to dispose of the representation. And my lord,
taking into consideration the Motor Vehicle Act, then rules framed there.
yes, and even the contents of the writ petition can be made part of the representation.
The writ petition has filed the present application praying for a direction upon the respondent authorities. To not to allow the vehicles with the not to allow the vehicles with the over and above the gross vehicle weight of the concerned truck of the vehicle of the concern of the concerned vehicle. Full stop. Counsel for the petitioner submitted, Mr. Binu Kumar, an advocate appearing for the petitioner submitted, the petitioners being the association.
Yes, madam, registered association.
The petitioner is filed with the association only. The petitioner or the association. Association and have constructed a wave bridge at Jirkatan, Nile Tilak for the purpose to waive all the trucks who are proceeding from South Andaman to Northern Middle Andaman via road. Counsel for the petitioner alleged that some of the vehicles who are over and above the weight of over and above the unleaded weight, gross vehicle weight are not passing through the wave bridge, due to which the road conditions of the said area has been badly affected. Mr. Binu Kumar submits that as per the provisions of the Motor Vehicle Act and the rules framed therein, no vehicle should be allowed to ply on the road above than the gross vehicle weights provided under the permit granted by the concerned authority. Full stop. Mr. Chakravarti, Nandan, senior advocate appearing for the administration, submit that the petitioner has made the representation, comma, if a direction is passed, comma, the authority will consider the representation and will pass the appropriate order. Considering the submission made by the counsel for the respective parties, this court find that the petitioner has made a detailed representation to the authority on 19th of June 2025, which has not been disposed of by the authority till date. Accordingly, the writ petition is disposed of directing the authority particularly the response number.
Phone number, why not, 3 would be appropriate, secretary.
Response number 3, that is.
And it will be better if all 3 to 6 be directed to jointly, Malad, to consider this, because they all are necessary. 4 is not.
Accordingly, respondent number 3, but there is a, I think committee,
Is there.
district, Mr. Chakravarti, there is a committee, I think so. All the things is to be, because superintendent of police, deputy commissioner,
The committee.
committee is there.
My lord, I am not sure if in that case, my lord may direct the committee, my lord. I am not, but I don't have instructions.
This petition directing the respondent authority to place the representation of the petitioner before the concerned committee, who is dealing with regard to the ply of the vehicles on road in the Andaman and Nicobar Islands, and the committee shall decide the representation of the petitioner within a period of 6 weeks from the date of receipt of this order, and to communicate the same to the petitioner within a week thereafter.
Number 3 may be directed to place before the committee, time frame.
The respondent number 3 being the secretary transport is directed to place the representation of the petitioner before the committee for discussion in the committee and for taking decision.
Within the time frame, otherwise.
ऊपर जाएगा ना 6 weeks में, the ऊपर आएगा. The respondent number 3 is directed to place the representation of the petitioner before the committee within 2 weeks from the date of receipt of this order, and the committee shall decide the same within 4 weeks from the date. If necessary, if the committee feels necessary, the opportunity of hearing to be given to the petitioner at the time of taking decision in the representation submitted by the. That's all. Yes.
But we have, Malad, filed.
Filed My lord, we have filed an affidavit, my lord, explaining, my lord, that there has been no violation at all so far as we are concerned. Because, my lord, proceedings were being carried out under the Public Premises Eviction or Unauthorized Occupants Act. So there is a specific bar to jurisdiction of civil court once these proceedings are carried out. Now, my lord, what happened in this case is that,
Mr. Prashant is not here.
yes, let him file a response, my lord. We'll let it come afterwards.
File the affidavit.
Yes, my lord, affidavit has been filed.
File.
Yes, my lord, we have filed this, thick
Supplementary
affidavit.
affidavit of the respondent concerned now. Affidavit on behalf of
The supplementary affidavit, my lord,
File.
we have filed in the.
record an order, none appears on behalf of the petitioner. The alleged contemners of file the affidavit plus supplementary affidavit. After serving the, you have served the copy?
No, copy has not been served, we thought, we shall serve the.
Serve it in the courts of it.
And appears on behalf of the petitioner, comma, the contemner, the Leonard appearing for the contemner is directed to serve the copy of the supplementary affidavit to the Leonard counsel for the petitioner by tomorrow. And the petitioner is liberty to file reply to the supplementary affidavit. This is the matter before the next circuit bench.
Most grateful, most grateful.
Next.
Like bear the order passed by Justice Raja Basu Chaudhary. There should be case report. Justice.
Record an order. This is an application for contempt. On the allegation, contempt, full stop. Contempt of the order passed by his lordship Raja Basu Chaudhary J. Also, the registrar is directed to transmit the record of this court or this case to the principal bench of placing and to place before the honorable justice to the honorable judge for this for consideration. Yes. Come. Yes, anybody is interested for a hearing matters? No one.
I can waiting for it.
Item number 17.
Item 15, my lord, I am appearing for the appeal.
You are interested?
It has the respondent has been directed to file the supplementary. Supplementary.
Supplementary paper book? No, next circuit.
No.
I can do it tomorrow, my lord.
There is a time.
21 can go to next.
Let me call one by one.
Retain the position. Right, sir.
Okay, supplementary record. Supplementary affidavit filed by you are for the appellant, Mr. Bin.
There is no appeal. Respondent in item number 15 and appellant in the item number 16.
The supplementary affidavit filed in essay number 5 of 2024 by the appellant.
Yes.
By the
Appellant.
appellant. Let the send it up with the record. This is the matter tomorrow. Next.
Your Lordship, what I am submitting is the coordinate bench has already passed an order relating to shop allotment.
Who is for the other side?
We have preferred and we are in the process of preferring an appeal against that order. It has already been drafted and sent, my lord. So only thing is let it simply go to the next circuit. If we are not able to file appeal in the meantime, of course, it will be decided on merits, my lord. Matter has to be decided on merits, but one of their arguments will be that coordinate bench has passed the order in case of another party. I am not disputing the fact that coordinate bench has passed that order. But there, my lord, the issue was slightly different because there was no defense taken. In this case, my lord, we have filed our affidavit in opposition. In that case, no opposition was filed. Of course, in review, we tried to bring those documents, but the issue is going to be review is limited jurisdiction. So, my lord, it cannot be equated with a situation where we have filed an affidavit in opposition, bringing our defense on record.
Same defense, Your Lordship.
No, but it's different because the review jurisdiction is limited. So, my lord, Even if the court appreciates our argument, it has to be seen from that prism of it being a review petition.
In 2 weeks, reply.
It's been filed, Your Lordship.
Opposition filed.
Opposition, no, opposition is filed. Now, what has happened is in that matter, my lord, no opposition was filed and the court passed an order. We went in appeal, court said file review. We went in review, then the court, while dismissing the review, may have appreciated those facts in a certain manner. But in this case, my lord, we have filed our opposition. So therefore, the appreciation will also be different when our opposition is filed as opposed to a place where it is only a review.
Mr. Chagwati, what you want?
No, we are preferring, one second, Mr. Dwivedi, we are preferring an appeal against that order. Let it just go to the next circuit simpliciter, my lord. Only that much I'm saying. Next circuit, if we are not able to.
Press for placing the, press for adjournment. According case adjourn, let the matter appeal to the next circuit.
Most grateful. I appreciate, my lord, we cannot indefinitely get the matter adjourned. If next circuit also we are not able to move the appeal, my lord, it will have consequences.
No problem, sir. Next.
My lord, I've heard substantially this matter, I was supposed to place the entire High Court's orders with regard to alternative land. All the orders have been annexed in the form of a compilation. Now, these can be.
Yes, have you gone through?
My lord, just now, see.
Hmm. Go to the order for tomorrow?
Mine.
Have you served the Mr. Jeffers?
No.
Just go through all orders,
Mine.
come tomorrow.
Some application.
Tomorrow, nothing. Mr. KMB Jaipal has filed the compilations of the orders after serving the copy to the council for the respondent. Let the same be kept with the record. Ms. Babita Das, government feeder, pays for time to go through the orders. According to let the matter appear tomorrow. Next. Vinu Kumar. Let the matter go to the next agreement. Let the matter go to the next agreement. Yes, next.
I'm for the
Petitioner.
I'm for the respondent.
Yes.
Twice this court issued a mandatory order. The matter relates to payment of premium.
Hmm.
But at one point of time, for the first order is by Her Ladyship Justice Samati Chatterjee. Mandatory direction, assess the premium, records needs to be finalized. In the second round, when it was not done, my petition was dismissed, directing the Tahsildar to initiate FIR against me. Because they take the plea that the license is a fake one. Then a division bench was approached, the order was set aside. On remand, this court again, can you see that order by Justice Somin Sen at page 39? It recorded my entitlement that I am entitled to get the same benefit which one has been given, that's Bridgelar. Again, the Deputy Commissioner passed the same order, which I challenge here. We have to comply the order, not they have to assess the premium.
Yes, madam.
Yeah, I can show every order.
What you are doing?
Kindly see page 32 by Her Ladyship. Of the city's order, they accepted. There is a mandatory order at page 34. Therefore, I dispose of the writ petition on substantially same terms as the other writ petitions by making followed. The respondent will immediately make an assessment of excess land held by the petition by consulting first and representation. If any of the petition by giving hearing to and by way of passing a reason order within a period of 8 weeks from the date of communication of the next order. Thereupon, the respondent will be empowered to take possession of excess land in the petition cooperative. The respondent will accept the premium and arrears of land revenue with interest at the rate of 10% per annum simple interest from the writ petition from the date of its becoming due till the date of its payment. Such payment is to be made within 3 months. In spite of this order, mandatory order, these are the mandatory orders, Lordship. It was not complied with. Then at one point of time when the order was not complied with, when I approached here, they said that the license is the fake one. Now to see page 39.
What document you relied upon?
License law.
Where-
License
Your name is appearing in the list.
No, madam.
It's not there in the list.
It is
But
not in the
this
list.
Lordship Honorable Justice Somecha Mehta would see that order.
Nowhere, it is
Correct.
only a
Because
license.
Justice Sen has passed an order directing the authority if you are entitled to. When we come to that, Justice Sen's order.
Page 41.
Yes, page 41,
Even
paragraph
the-
9, in the event.
Yeah, in the event.
The claim of the writ petition is established to the extent the same benefit of be extended to Ramkishan.
There can.
To Ramkishan.
No, there is one more same parity of reasoning, same person is there, the same footing which my client is there. So same benefit.
That's the same benefit.
Has to be extended to my client.
Yes. Then
Lordship, page 43 came to be passed by the Deputy Commissioner.
he is telling that you have not produced any, what are you talking?
The license I have produced.
That is the fake license.
License, the same, his fake issue has been decided by the division bench.
Not a single document. he
Where
can
is the
produce.
division bench
I
order?
have shown her that order. Because. I can show.
It's not division bench order.
It's not the next, I'll show them that order.
Bring the division bench order.
My lord.
Yes, madam. You file the affidavit
Yes, madam. I have already filed my opposition.
as per the prayer made by the council for the petition. Let the matter affect tomorrow. Next.
We have filed our affidavit, my lord, in this case on behalf of the administration. I have also received instructions to appear for the ministry, my lord, in this case.
Third.
Yes, my lord, sir.
My lord, it may be recorded that I am appearing for the ministry also, my lord. I have received instructions.
Design the impugn judgment order on one Director Industries. Yes, Mr. You will file reply.
I'll file.
Ministry will file any affidavit. Mr.
My
Chakravarti?
lord, may give us the opportunity, my lord. Let them also get an opportunity.
The Just one number.
2 to 5 have filed.
And their affidavit. Concept of the petition. Advocate appearing for the Union of India.
All, my lord, we are appealing for all.
Yes, no, that is what we have now received instructions to appear for the ministry also, respondent number 1 also.
The senior advocate appearing submits that he has instructions to appear even Union of India. Accordingly, he prays for time to file affidavit in opposition in connection with on behalf of the Union of India. Union of India. Let affidavit in opposition filed within 3 weeks. A reply, if any, there to be filed within reply to the affidavit in opposition of the respondent number 228, 224, 225, and
2 to
and connection with the different respondent number 1 be filed within 2 weeks thereafter. Place the matter before the next available circuit bench.
Sure.
most great.
Yes. Next.
22.
Lord, I am appearing for the petition at this time. It is against the order which denied the connection of electricity on the ground of daily after regulation.
Come tomorrow. That matter is fixed tomorrow.
Sorry to mention.
Not today.
My lord, I already passed one order. Same thing was before the court number 1.
Which one? Municipal?
Case of FMAT, Airport Authorities matter. Second direction, same direction needs to pass in this case. Those 2 matters were delisted. I want this inclusion of these 2 matters. Same order.
But
Well, this is the order my lord has passed. Same order. These are 2 matters which were before court number 1. I got it delisted.
Acha, that one. FMAT. Have you served the copy to Mr. Zino? Inform me Zino.
Yes. I have informed in that person's delisting order.
We mentioned.
Allowed if permitted, I would like
उसको ना वाला
to.
अरे बाबा इसको इलेक्ट्रिसिटी वाला मतलब yes.
But with regard to item number 2, the quantum of fine is 1,000 rupees that has been reflected.
Which one?
Item number 2, madam. But at that relevant point of time, the act says that it is up to 500, but that thing may kindly be.
What time?
Uh,
No, which
2016,
year, which year?
2016, my
This
lord,
incident was occurred?
2016.
Item number 2, 2016 incident. अपलोड हो गया ना? Incident of 24. अच्छा 16.
Yes.
And what is the fee?
Up to 500.
You have old mic?
ये दे दीजिए।